he's saying, are we specifically not addressing when there's a dispute? That's sort of advanced guardianship, and we're here for basic guardianship. Jumping ahead, if you want to be a guardian or a conservator, you have to put yourself forward, which generally means you have to file a petition. I have had 5 petitions filed on one proposed ward at one time, and then everybody comes into court with their lawyers, some without, and then they present their case as to why. First of all, it's what we call a bifurcated hearing. Is there a need for a guardian and or conservator? And then who is the appropriate person? So you have all of the evidence as to what needs to be done for this individual. And then you have all of the evidence as to who's been doing it, who knows the most, who's gonna not secret the ward away from the other people, who's not gonna fail to consent to necessary medical treatment, who's not an alcoholic and leaves the kid at home while they go to work for 12 hours a day. All kinds of, who's not abusive. And we get into this a lot with dementia patients and kids where they have differences of opinion, and 5 or 6 of them think that they're the right one and everybody else is evil. So at the hearing, again, by clear and convincing evidence, the petitioners all have to show that there is a need and who the right person is. And the conflict can be very basic, or it can be really complex, and it can take, we've had 3-day hearings on guardianships as to who the right person is. And
this is where you might see a guardian ad litem be appointed.
You will. As soon as you have a second petition, 99% of the time the court is going to appoint a guardian ad litem. I'll also say that you guys have seen coverage of ugly divorces and child custody. I mean, the Kathy Ireland, or the Ireland was their kid's name, where Alec Baldwin and his wife had that custody battle over their daughter and stuff. We have smaller versions of that case in Cobb County every day. If that child that they're fighting over happens to be disabled, all it does is give them a second bite at the apple when this kid's turning 18 and we're doing a guardianship of them as an adult. And it gets just as ugly and just as heated and just as he's awful, she's sleeping around, whatever they want to get into. So we have those same kinds of situations with these cases. So it's the same kind of thing. So we do have some very hotly contested guardianships, but that's where it's decided.
Responsibilities of the guardian. A guardian must be available to the ward. That's one of the requirements. Must act in the best interests of the ward. Must timely file all the required reports. Must use the ward's resources for the ward's benefit. Anybody have any trouble with any of these? You're doing it anyway, right? Honestly, when I hear people complain about guardianship, it is not guardianship they're complaining about. They're complaining about conservatorship. So, you have to inform the court of any conflicts of interest. This is one of those obscure little rules, which I actually ran into. Mom was the guardian. Mom was driving a car. Adult daughter was sitting next to her. They were in a car accident that was mom's fault. Daughter was injured. Daughter now had to sue mom in order to get the insurance to pay for her medical bills. That's a legal conflict of interest. Mom cannot serve as daughter's guardian at that point. The court has to appoint somebody else until that conflict is resolved. It's in the law, it's there. I don't even know why I spend time. Okay, and